Interpretation of the law by the courts is a fundamental part of the legal system. It is through the interpretation of the law that the courts are able to determine the meaning of the law and make decisions regarding legal issues. The first factor in the interpretation of the law is the text of the law itself. The court must look at the text of the law and determine its meaning. This is done by examining the language, the context, and the intent of the lawmakers when the law was enacted. The second factor in the interpretation of the law is the legal precedent set by prior rulings in a similar case. The courts look at previous ruling to determine how the law should be interpreted. This helps to ensure that the law is interpreted consistently. The third factor in the interpretation of the law is the application of legal principles. This involves applying the relevant legal principle to the specific facts of the case. This is done to ensure that the law is interpreted correctly. The fourth factor in the interpretation of the law is the court's own understanding of the law. This involves the court using its own knowledge and experience to interpret the law. This is done when the text of the law is not clear or when there is a lack of precedent. The fifth factor in the interpretation of the law is the court's consideration of public policy, as the court must consider the impact of the ruling on society and the potential consequences. The interpretation of the law by the courts is an important part of the legal system. It is through the interpretation of the law that the court is able to ensure that justice is served and that the law is interpreted correctly. It is important for the courts to consider all the factors mentioned above and more when interpreting the law. Hello everyone, welcome to another episode of Naija News series. Kindly subscribe to the channel, hit the notification button, give us a thumbs up, and leave your comments. The Independent National Electoral Commission (Inec) is at liberty to prescribe the manner in which election results are transmitted. Courts. A federal high court sitting in Abuja has told the Labour Party that it cannot compel the Independent National Electoral Commission (Inec) to adopt electronic means of transmission for the results of the 2023 general elections. The court made the declaration in a judgment which was delivered on January 23rd, about a month before the February 25th presidential and National Assembly elections. Labour Party had, in an originating summons filed on August 2022 with Inec as sole respondent, asked the court to determine whether, having regards to combined effects of Section 47, subsection 2, Section 50, subsection 2, Section 60, subsection 4, Section 60, subsection 5, and Section 62, subsection 1 and 2, and other relevant provisions of the Electoral Act 2022, the Commission can still insist on manual collation of results in the general elections. Labour Party asked the court for two injunctive reliefs in the event that the question was resolved in its favour. These include a declaration that the respondent has no power to opt for manual methods other than the electronic method provided for by the relevant provision of the Electoral Act 2022, an order of this Honourable Court directing or compelling the respondent to comply with the Electoral Act 2022 on electronic transmission of results in the forthcoming general elections. However, Inec neither responded nor filed any process in the suit. Labour Party's lawyer, Monday Mowa, in the argument submitted to court, argued that in view of the provisions of the law, manual collation of results was unknown to the Electoral Act 2022 and therefore must be rejected or disallowed by the court. But in his judgment, Justice Emeka Nwite held that Section 52, subsection 2 of the Electoral Act 2022, cited by Labour's Party Counsel Monday Mowa, provided for voting and transmission of results in accordance with the procedure to be determined by Inec. The judge ruled that Inec is at liberty to prescribe or choose the manner in which election results shall be transmitted. Justice Nwite said it is indeed a trite law that the function of the court is no more than interpreting the law. In interpreting the law, the court is enjoined to interpret the statutes as they are without going outside them to bring in what the court would think was intended, citing previous case to back his ruling. According to him, the function, roles, and duties of the court in interpretation of statute is to give meaning and effect to clear and unambiguous word of the statute. The judge said, from the arguments of the plaintiff counsel, the bone of contention or the section that sought for interpretation were Section 50, subsection 2, Section 60, subsection 5, and Section 62, subsection 2 of the Electoral Act 2022. He said Section 47, subsection 2, as cited by the lawyer, only dealt with accreditation of voters using a smart card reader, but not collation or transmission of results as postulated by him. The said Section 62, subsection 2, has mandated that such register of election results shall be kept in an electronic format by the Commission at its national headquarters. Now, a close reading of Section 50, subsection 2, has provided for voting and transmission of results to be done in accordance with the procedure to be determined by the Commission. This is to say that the Commission is at liberty to prescribe or choose the manner in which election results shall be transmitted, he said. Nwite equally held that Section 60, subsection 5, empowered the polling unit presiding officer to transfer the election results, including the total number of accredited voters and results of the ballot, in a manner to be prescribed by Inec. In view of the foregoing, can the act of the defendant, Inec, in collating and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provision of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited section where the Commission or any of its agents is mandated to only use an electronic means in collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a way or manner deemed fit by it. In view of the above, I find that by the provision of Section 50, subsection 2, and Section 60, subsection 5 of the Electoral Act 2022, the correct interpretation of the said statutes is that the defendant, Inec, is at liberty to prescribe the manner in which election results can be transmitted, and I so hold, he said. The judge consequently dismissed the suit. Well, guys, this is some new information, and I just thought it necessary to share, because most of us don't know this case had been held even before the February 25th general elections, has already ruled in favor of Inec with regards to the transmission of election results. So let's be informed before we do any argument. Well, guys, that's the news for now. Kindly subscribe to the channel, hit the notification button, give us a thumbs up, and leave your comment. Until next time, bye.